as to bond.
It's a low BAC for one thing. The accident that's alleged to have occurred is actually a result of the neighbors parking illegally in front of their house.
You're to test right now. What's in your system?
I would object to that question. It violates the Fifth Amendment, that a judge cannot ask incriminating questions, even if it's only for purposes of bond. The Fifth Amendment is not changed.
Counsel, I'm very much aware of that.
This was just another run-of-the-mill drunk driving arraignment in front of Judge DiSanto until the defendant's hired attorney came in swinging. At first, he complains about the disconnect private attorneys have getting discovery. Then comes the discussion of the defendant's bond. I like this lawyer's argument as to why his client should keep her mouth shut, and his argument is technically correct. Judge DiSanto knows. She also knows that once the defendant is on bond, she can order the defendant to pee in a cup, and then she'll have her answer. Let's roll those.
Abigail Voluminous, 25892 A and B.
Thank you very much, Your Honor. William Mays on behalf of Ms. Voluminous, who is approaching. State your name for the record, please.
Abigail Voluminous. Okay.
And Your Honor.
I feel like good morning. I feel like you've been here recently.
Me or her?
Client.
So my son.
That's right. Okay. All right.
Not me.
Nope.
So, I think this is arraignment pretrial.
It is.
All right, we'll waive reading as the court to enter a not guilty plea for purposes of arraignment. Insofar as the pretrial is concerned, I have been going back and forth with the prosecutors quite a lot over a discovery issue. I have a copy of the police report at this point. We discussed released videos of MSP blood. We had a lab this morning. Well, actually, we've discussed it in the past, but we've discussed it again this morning. They have a proposed order that I oppose that would require my client or my office to pay for discovery. There's been a lot of discussions about this under the new court rule pertaining to discovery. I do have a motion I can file. I've offered to file that motion if they require it, but upfront fee for rudimentary discovery is not permissible, and frankly, I don't deal with going to the police departments to ask for my discovery. I leave it up to the prosecution to provide me with the discovery that they have, and if they don't have it and they're required to have it, then I rely upon them to go out and seek it as they're required to do. So I would oppose, there's a proposed order in the file that would require us to pay the costs of the discovery. I would oppose that order. I can file a motion if you like, Judge. I know that there's been some discussions about this on the District Court Judges Association forum recently as a result of some of my motions I filed in the recent history, but whatever the preference of the court is. But we do need our videos, and we do need our toxicology, MSP laboratory documents.
Okay. And so, counsel, you are opposing the order that's put forth, but you did not yet file your motion?
No. This is our first pretrial. I've emailed the prosecutor several times.
Right. I understand that. And you're aware of the discovery order that the prosecution uses in this court, but you didn't yet file a motion?
I don't know if I'm aware of their standard order. I saw it this morning.
This is the first time you've been in this court, counsel. You're aware of what the discovery order is.
I mean, they're new prosecutors. They just recently.
I understand.
Yeah.
But it's a similar order as typical. So we will adjourn this, and counsel, you can file your motion within that time. So it gives the prosecution an opportunity to respond to your motion.
Well, I guess before I file a motion, I would just ask for what the authority is for them to charge or discovery. There isn't.
Well, counsel, you're indicating you're objecting to the order that's put forth.
Yeah.
Because you don't want to pay as what's put forth in the order
Right.
that is in here. And this court is not prepared to hold arguments by both counsel and the prosecution at this point as to whether there should be costs or should not be costs. So that's why I'm instructing you to file the motion that you've indicated that you have ready to go.
Yeah.
So let's adjourn the pretrial to October 29th, and then we can set the motion hearing for October 8th. That gives time for you to file the motion, prosecution to respond, and then the court to make a ruling on that. And then you can still receive your discovery in time for the pretrial. As to bond,
I would ask for personal recognizance. My client is going to, it's a low BAC for one thing. The accident that's alleged to have occurred is actually a result of the neighbors parking illegally in front of the house. And we're not talking like a car accident. We're talking about an allegation that she clipped the car while they were parked in front of her driveway on the wrong side of the street. I might add, pointing the wrong direction. And it's a low BAC, like I said. So she's going to fight this case. She's going to contest these charges. So I would ask for personal recognizance.
all right. And so, ma'am, have you ever failed to appear for court? I'm sorry?
No, sorry.
All right. And are you currently on probation or parole anywhere?
No.
Out on bond in any other jurisdiction? If you're to test right now, what's in your system?
Judge, I would object to that question. It violates the Fifth Amendment. Or potentially violates the Fifth Amendment.
In what regard, counsel?
It requires a person to speak as to any substances that they may have in their body. It requires them to waive their right of silence under the Fifth Amendment to potentially incriminate themselves.
Okay, I can assure you, counsel, that it's only for purposes of bond. The court's not going to indicate one way or the other that there should be a case filed if there's something illegal in your client's system.
I don't
For
think.
purposes of bond.
And actually, there's that case out of the Western Holland, I believe, where the judge required the person to say that and held the attorney in contempt of court for instructing his client to refuse to answer that question, where Judge Post blew up, became a big headline story.
Okay, well, I don't really read the headlines, so what case is that, counsel?
Well, Judge Post was removed from the bench for a period of time.
Counsel, I'm not asking about that. I'm asking what's the case citation?
I don't have a case like in the Fifth Amendment.
You indicated there
I
is,
asked my client to incriminate.
counsel, you indicated that there was a case in Western Holland. What was the case?
It's Judge Post, 50, maybe it's Hudsonville.
Oh, so there wasn't a Court of Appeals or Supreme Court?
No, it's the JTC judge.
Okay.
They removed Judge Post from the bench.
Counsel,
Yes.
you're not answering my question. When you stated there was a case in Western Holland, I was anticipating there was a case that was either heard before the Court of Appeals or the Supreme Court or whatnot. So I was expecting I was going to be writing a case citation down. So that's what I was asking you.
I would assume it's in re Judge Post
Okay.
from the JTC to indicate
Okay.
that, in fact, the attorney's position was correct, that a judge cannot ask incriminating questions, even if it's only for purposes of bond. And this is nothing in particular to this particular case. This is universal, that it's an improper question to ask a person what might be in their system.
Interesting.
Yeah. If you'd like, I can provide you with authority for that at our motion hearing on the 8th.
And when did all that make the headlines?
I'm going to guess it was 8, 9 years ago, maybe 10.
Oh, okay.
The Fifth Amendment has not changed in the interim.
Counsel, I'm very much aware of that. Very much aware of that. Would there be any alcohol in your system, ma'am? Counsel, I can ask that question. That's not an illegal substance that could continue, that could somehow result in any illegal possession charges. So here's what the court's going to order. The court's going to order your cash bond to be continued. You're not to possess or consume any alcohol or drugs that are not prescribed to you. And counsel, it's my understanding, well, I'm going to actually look that up because I don't know if that specific, I don't know what other subsequent issues or if it was perhaps behavior, what have you. I'm going to look that case up to see what exactly it was as to what occurred, because it doesn't appear, so that's not, that hearing is based upon the judge's behavior or conduct or whatnot. There's not a case ruling on that in that regard, because the court is permitted to ask if somebody has anything in their system, even for purposes of plea, to make sure that they're not under the influence of anything. So the court does have that authority and that discretion to inquire as to that. And ma'am, where is it you work?
I'm a therapist at a nursing facility.
Okay. All right. As I've ordered, you're not allowed to possess or consume any alcohol or drugs unless prescribed. And I'm just going to order no assaultive contact with your neighbor. Assaultive, threatening, abusive, or intimidating contact. And just have a seat. You'll get a copy of your bond conditions. And then we will see you back on October 8th and November 5th.
Thank you, Judge.
Thank you. Have a good day.